Now, we are moving on to our third and final panel discussion for today on the topic Managing GST Litigation. I would like to welcome our panelists on stage, please. CA Rohini Aggarwal, Principal Consultant at ARX Business Advisors LLP. She has academic and industry experience of over 30 years, mainly dealing in indirect and corporate laws. She assisted World Bank in completing their prestigious Doing Business project relating to indirect taxation in India. Please. Mr. Sudipta Bhattacharjee, partner Khaitan and Company, whom we all have heard in the previous panel. Ms. Charanya Lakshmikumaran. Ms. Charanya is a partner in the tax litigation division at Lakshmikumaran and Sridharan. She is a qualified advocate on record with the Supreme Court of India. Her experience in the field of tax disputes spans over a decade. Mr. Shankey Agarwal. He is a partner at BMR Legal. He is an advocate and a qualified company secretary with over a decade of robust experience in direct and indirect taxation. He specializes in tax litigation and has been involved in a number of high-stake litigations. And our moderator for this panel discussion, Mr. Somesh Arora, whom we all have had the opportunity to hear in the previous session. Over to you, sir.
So we are in the last panel discussion of the day. We have very knowledgeable panelists again. Charanya, of course, is on my right side. And, we have Mrs. Aggarwal there on this thing, and Mr. Bhattacharjee and Shankey Aggarwal. Friends, the topic for discussion for this afternoon now is the GST litigation. I think it's the least touched topic in the last 5 years. I'll not be wrong in saying that. Whatever litigation we have seen is by advanced ruling authority. Of course, Mohit Ispat is one big sparkling judgment which has emanated from Supreme Court. And apart from that, whatever litigation we have seen is largely confined to high courts on issues of administrative lack of action or whatever, or on procedural lapses. So there are doubts as to what is going to be the complexion of litigation once it comes up in a big way in this thing, and what should be the response system of the business to what are the matters which should be taken up for litigation. Panelists are there, I'll open it out to them. See, when we express doubts of the business, we have to keep in mind as to what kind of litigation is envisaged in GST law. Firstly, is the only place of supply is one issue which has been kept that will go to the GST National Tribunal from First Appellate Authority, and then it will travel to Supreme Court. Rest are all matters which will be open to High Court, and then they will travel to Supreme Court. Interestingly, classification and valuation matters, which in case of excise and even customs, have been kept at such a level that the appeal travels from tribunal to Supreme Court, have not been kept so far in the domain of GST National Tribunal. So peculiar situation arises that even on the matters of classification, you will be traveling to all the tribunals, High Court, and then only the matter will come. A uniformity is always required in matters of classification, whether of service or for this thing. But it's not going to be there. And when we talk of litigation, imagine what is required under law. That you firstly admit any liability if you want to. If you do not, then the first appellate stage deposit 10% compulsory deposit. At the appellate stage, deposit another 20% of whatever has been deposited in addition to that. So it becomes 30%. And then when you are going to High Court, there's a particular provision. The appeal can lie to High Court, which says, including on valuation and classification dispute, there's a particular section 19, which says, notwithstanding anything contained or anything done by the High Court, recoveries can be made as far as orders passed by the tribunal are concerned by the department. So, virtually whether it is taking away the power of High Court to grant stay, and only Supreme Court can grant stay, and that too when 30% has already been deposited of the disputed amount is going to be a question foremost in our mind. Litigation is so expensive under GST. And practically how it works, classification dispute arises. Now as a businessman, you have two choices, either to agree to whatever department is saying, even if you feel it is obnoxious, the classification is obnoxious. Or secondly, to litigate. If you want to litigate, if you are the only one fighting the battle, not your association is doing the job, then you have the option either to charge from your customer or don't charge from the customer. Start paying whatever department says and start charging from the customers. Willy-nilly agree to whatever department says without challenge. Don't litigate it. Second option is go through association, take the route of maybe writ or straight away SLP. If litigation is there, don't go through the channels of first appellate stage and second appellate stage. Moment you receive a show cause notice, try to move in SLP in Supreme Court and try to get a justice as early as possible without paying interest cost. Interest cost is again prohibited. 18% on you for every delay or every demand which is finally confirmed, and 6% in case department has to pay back. I normally say the interest is a parallel levy without authority of law. And then you have the penalties which are 100%. Not only the interest is penal, it definitely works against you vis-a-vis whatever the government pays you. So you have little option left and very little scope financially as a businessman to litigate to, I'm not talking of the litigation costs and all that. So what can be the likely scenario and what are the various issues and what could be the best advice we can give to the business as to what to do and how to litigate, and whether it is time that GST litigation becomes an association driven litigation only. You have to have good associations who understand the issues that, okay, this is the wheat differentiated from the chaff. This is the case we would have litigate, and we have to litigate cumulatively, because alone I don't think you will be able to litigate on issues like place of supply and others, given the costs which are going to be on your head eventually. If the litigation has to take some 5-10 years to reach the finality. So these are some of the issues which are coming to my mind. I'll ask my panelists to kindly address to it. To my right is Charanya, a very young budding lawyer. I've always seen her in black robe. Today she's looking so graceful and this thing.
Thank you so much.
Yeah. So kindly.
Sure. Thank you, Somesh sir. Thank you everyone. Thank you Oakbridge and Taxo for having and organizing this. I think the timing of this is a little interesting and nice. After the first week of the 5-year of GST, I think everyone has had time to reflect, and about 15 days later, it's nice to get back together to discuss this. So I'll just give my initial thoughts on, observations or comments on what Somesh sir was just mentioning. First is, how is litigation going to pan out once it actually starts? And he's absolutely right. The first 5 years was there. We feel there was a conscious effort on part of the government to not encourage litigation or to not initiate as many investigations, as many audits that we are now seeing perhaps in the last 6 months to 1 year. The kind of energy that we are seeing on that front. It has been because they wanted the industry to settle down. They wanted issues of ITC, issues of place of supply possibly, and a few other issues to sort of settle in. I know we were all struggling with the Tran one, we've been struggling with returns, we've been struggling with automation and auto population and things like that. But I think now in 5 years, there is some sort of understanding of how the Act will operate. Litigation is there. It is, we're already sensing it. All of us are litigating lawyers here. We know it because the number of investigations, the number of audits that have begun is phenomenal, right? And I'm sure everyone here is going to agree with me when I say that. But what is going to be the fate of this litigation, right? It's very interesting to hear that, is it going to be association-wise litigation, or is the litigation cost, and not just the legal fees that you have to pay or the number of years that you're going to be stuck before one forum and an appellate forum and a further appellate forum. that apart, just the prohibitive interests, which is actually penal in nature, to discourage people from hedging on the interest component between what they will get in the bank versus what they will get back. So it is penal in nature in that sense. So there is a feeling today that maybe people will not litigate, right? The whole idea of GST was to reduce as many friction points as possible, but doesn't look like that's what the future holds. Looks like we are in it for a long haul. We are, I may not say association-based litigations, but we are going to see batch matters. Issues of classification going to different high courts. Already we are seeing advanced rulings from different states holding for the same SSC, having completely different classifications in different states, completely different eligibility issues in different states. We are of course missing 2-3 key components in the litigation and the justice delivery system when it comes to GST, which is the lack of unified body to harmonize the advanced rulings that we're getting today. The lack of the GST tribunal, right? Something that everybody needs and everybody wants, and that will really send a clear message also to the departments, to the industry as to how the litigation and how GST further is going to shape. So I'm going to stop here and perhaps give it back to Somesh ji.
I'll request Mr. Bhattacharjee to kindly give us the point of view. Of course, advanced ruling authorities, there were a lot of expectations. Initial phases, everybody was looking for advanced ruling authorities. The GST tribunals are still not in the picture. But somehow, people feel that some kind of a revenue bias is there. There's no member judicial or any independent member. Both members come either from the state tax or from central tax. Nobody who's independent, no member who's a member of the judiciary. And then the worst thing about advanced ruling authorities is you can reach a dead end. Or you go to appeal and there's a difference of opinion, not happened in many cases, but yes, it has happened, 3-4 cases. There is difference of opinion and it becomes a nullity. So at the end of the whole litigation, making appeal and still not arriving at this thing. So this appears prima facie anomalous. Why a provision like this of kind of to be made? There's been any judicial forum anywhere where you don't have a dispute resolution process between the differentiating members, but here it is there. It becomes a nullity. So very peculiar kind of a feature of even advanced ruling authority. I'll ask Mr. Bhattacharjee to kindly give his views about the kind of litigation.
So I think if I divide litigation and the GST in 2 buckets, one is merit-based. You're taking a particular interpretation, does that interpretation sustain, not sustain, does the revenue agree, not doesn't agree. The second bucket is, very broadly speaking, I call abuse of power litigation. Abuse of power because at the flimsiest of excuse, your trucks get stuck. At the flimsiest of excuse, search, seizure, raids happen, provisional attachments are happening, registrations are getting cancelled or suspended. I don't think anyone has the luxury to wait for an association or a batch matter sort of a scenario for abuse of power litigation. We will have to walk the talk. Fortunately, for abuse of power litigation, typically high courts have been welcoming, have been relief giving. Of course, now in the context of e-way bill, etc., quite a few high courts have started pushing back, saying there is alternate remedy, why don't you go and appeal, etc. I wish they would be more open. Yes, I agree there are statutory appeal, but I think it's a illusory appeal given for how flimsily or how low the threshold is to invoke provision section 129, and that's that sort of a provision. Now coming to merits, yes, I think association is definitely a good idea, or clubbing together, people sort of coming together, sharing the cost, and I'm sure we'll see more of that. One of the things that we had suggested when GST came in, because what is the client, what is the businessman looking for? For certainty of tax position. Even if tax has to be there, we need to know, especially because this is an indirect tax, we can pass it on to the customer mostly. So to that extent, certainty is what we are looking for rather than optimum or exemption or a concession. And one of the things we had suggested, and not some earth-shattering genius of an idea, but what we had said is, go to advanced rulings, you can be certain that the outcome would be adverse. Go for appeal, then go for a writ. That way, at least in the first 3-4 years, you are achieving some sort of a certainty of tax position without fighting a litigation where there would be a pre-deposit of up to 100 crores. When the 30% is capped at 100 crores. So that is one thing that obviously, advanced rulings are allowed even for ongoing transactions, and to that extent, that route is still open. So I think that is one way to optimize merit or interpretation-based tax litigation. But I don't think that we are moving the needle much in terms of the expense. It remains an expensive proposition. Unfortunately, I don't think we can do away with it.
See, another issue which relates to advanced ruling authorities, multiplicity of rulings and conflicting rulings also from state to state. And they say it's binding on the party. Whether it is a precedent value or not is still to be decided. The matter is before the Delhi High Court. But as far as judicial discipline is concerned. But what we find is a multiplicity of things coming. And what you find is, same thing getting assessed at different courts or different states at a different rate. This is the outcome of whatever has happened, because of conflicting rulings coming. So how that can be resolved and how it can be, something which can inspire confidence in the litigants that, okay, advanced ruling authority is a good route. Supposing changes are made tomorrow and you make some judicial member also part of advanced ruling authority, so as to offer a objective view rather than revenue biased. So in that case also the effect of multiplicity of ruling in various states will still remain. So how to overcome that, I'll seek a view of Mrs. Rohini Aggarwal kindly.
Thank you, sir. It's an absolute honor and privilege to be with so many learned and experienced professionals with me. My gratitude to Atulji and his team for inviting me here and making me a participant in this discussion. My warm regards to all. So I think let's come back to the issue which we are doing. We are talking about litigation, and as Somesh ji has explained, litigation practically, we don't have many channels of litigations available in GST. We get stuck at High Court if we want some meaningful litigation as on date. So a very, very strange thing for a tax law as huge as GST. We don't have tribunals, and we all know that advanced ruling authority is practically of no use. Yes, of course it is of use to the extent people want to take a negative advanced ruling, because very interesting, because we people are also very creative. And what I have seen that the first problem with the advanced ruling is that the authority is at the level of joint commissioners or additional commissioners. So they are practically revenue officers. They are not they do not have that judicial kind of an aptitude. So the focus is revenue, then what kind of ruling we are going to get, we know. And very interestingly, nobody reads GST law. And this is a totally different law, transaction-based, process-based. So that is why we find so weird rulings. So we can actually be sure of getting weird rulings, particularly when we talk about the topics like taxability of vouchers, जैसे वो कल्याण ज्वेलर्स है. अभी एक बहुत ही weird ruling IPL के games में आया कि उसने पंजाब में कि complimentary ticket दिया उसने पुलिस वाले को भी, तो वो बोलता है कि ये भी इसको भी taxable होना है because ये आपको बदले में कुछ मिलेगा. अब क्या मिलेगा nobody knows. वो ठीक है कि उसका जो appellate authority now they have given a wonderful ruling. But that is not the point. We can't keep running after these kind of things. तो अभी at least आज की डेट में अगर हम solution की बात करें, this is the problem, we all know. This is the problem. If you go to advanced ruling, you will get a negative ruling. You go when you have to seek a government tender, so that in the tender you want to charge the tax, some other parties are not charging the tax, you want to go to advanced ruling authority and bring an order and to show the authority, see, it is chargeable to tax, so now I can charge the tax in my quotation against your tender. I think most of the people were doing this. So if you really are doubtful whether your thing is taxable or not, please don't go to advanced ruling authority if that is not the case. That is my suggestion. I may be incorrect. So practically, we are not with any remedy. And if we look at the structure of High Court rulings, like what kind of cases have gone to High Court till date, very, very strangely you will see that 80% of the cases are relating to procedures. Tran 1, I could not file Tran 1. Hundreds and thousands of cases maybe. रास्ते में सामान रोक लिया. My truck was going, he did not let me go for any flimsy ground. I think a very big bunch of the rulings are there. And if you look at the substance, like ITC, whether like Supreme Court, this Mohit Minerals, which is on the fundamental, you can actually count it on fingers. So practically in these 5 years, after GST, what has happened, earlier substance used to be supreme and the procedure used to be subservient. Now it has become the other way around. The procedure is supreme and they make the provision which suits the procedures. Like GSTR 2-3 नहीं आ पाया तो GSTR 3 भी आ गया, and because GSTR 3 भी आ गया, we change the procedure, we change the law accordingly. So very interestingly, like, I'm just mixing the two things because we want to find solutions. Litigation, very clear, it is expensive one. We don't have a way out except High Court, and High Court, how much they will do. And interestingly, the one very मायूस करने वाली चीज़ जिसको मैं कहूँगी, I'm not finding the right word in English for that, कि even if High Court gives some good ruling, nobody else follows. Department keep doing the same thing again and again. And the most pathetic thing, the first level appellate authority जो मेरे पास department में है, you always expect negative from that because the same authority, same department, they issue show cause notice to you. You go argue and then you go to the higher level. You will not get a positive order. So now it has become, and they are having revenue target in customs, as I know now, their promotion is dependent on the revenue which they earn. So if that is the case, as a fundamental, how we do expect to get some good outcome from whatever litigation we are doing. So what should we do? I think that is the basic question which we all want to answer. So to my mind, when we are talking about the citizens group, like we don't have to make new groups, in fact. We have our Institute of Chartered Accountants, we have so many organizations, but I think this is the high time when people should talk about the flaw in the policy. How much we have cried for tribunal, I have not seen any cry. Twitter page, like why don't we flood the social media with the need? We keep hearing, we go to the officer, he issues summon me for anything. Aapka input tax credit match nahi ho raha, he will send me summon under section 70. How many of us, pure Haryana mein, I'm just giving an example, I think thousands of people at the same time they got the summons under section 70. So my point is that, yes, we need to come out, and wherever there is something like this, collectively or through some organization or even individually, there are mediums. हम अभी मुसलमान हिंदू का बात होता है या कुछ भी, we flood the Twitter like anything. So why not GST? I think that was just a little bit.
Two very interesting points have been made by Mr. Agarwal. One is, go to advanced ruling. In fact, when GST came into existence, we were advising everybody to go to advanced ruling, 10,000, and you get an opinion. And you don't get, it's legally binding on the department, you don't get same kind of a respect or even a legal opinion given by an advocate. So we were also advising, go with that. But seeing the attitude, the things have come to a pass where, as you rightly said, go to advanced ruling authority only when you want revenue biased certainty. It will be certainty, of course, but it will be totally revenue biased. As you said, going for tenders and all that. So that's one point she makes. I totally agree with that. Second, she said, litigation, the complexion has been that high courts have been flooded. Very petty matters reaching them. My e-waybill was having this entry, not that entry. My truck being stopped, procedural lapses, blah, 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 blah. So is High Court meant for that kind of a litigation? They also understand there's no tribunal. Where will they go? And perhaps there's an appreciation that even at the lower level, there will be no this thing of the procedural lapses. And you can't find fault with them also, because see, if they, at the official level, if they start ignoring procedures will lose any sanctity. What I had suggested at one point of time was that within administration only, why don't you empower officers like chief commissioners and others, that for procedural infractions, they will have the power to condone. Put a fine which is prescribed in one of the sections for procedural lapses up to 10,000 or whatever, and then he condones it. High Court will be having lesser burden. Procedural lapse will be brought to the notice of the higher authorities. Some sufferance, but not so much, right? And then the executive authority itself, the higher executive authority, will be able to condone the procedural lapse. But the problem is, who will decide as a procedural lapse or substantive? We as a lawyers or the chartered accountants, we keep on saying there's a procedural infraction only, so it should be ignored. So even for deciding it's a procedural infraction, we have to travel to the high courts. So somewhere, if that kind of a mind is applied within the administration, I think a lot of litigation can be reduced, at least on the procedural point. We all know, there have been various court rulings. The procedures are, as a lawyers, we normally, don't give so much of importance. But those chartered accountants or even lawyers who are dealing with compliances, for them it becomes sacrosanct. And naturally, even for the officers, up to a certain level, they have to. They can't ignore their own procedures prescribed in this thing. And it's for not for them to decide whether it's a substantive law infraction or procedural. Within the department, such a course of system should exist, and maybe ask somebody who has done procedural violation to pay 10,000. High courts exonerate them altogether. You ask them 10, 20,000 and set them free, right? He's penalized to some extent, but not that. Even the litigation cost will give me much more to get a pronouncement that is a minor procedural infraction only and nothing else. So that could be one of this thing. I'd like to solicit views of my friend Mr. Shankey Agarwal on the kind of litigation which he expects and what could be the response of the trade to it. Please.
So just before that, I would just like to make one, just supplement Rohini ji's point. So one is, of course, the way advanced ruling is functioning. So my view was, on advanced ruling part at least, was that, when GST was brought in, and the expectation was that, there have been a learning of so many decades from the old laws, central excise, service tax, VAT. So, the expectation from the government was that, they will learn from their past mistakes or their past experiences from the authorities and tribunals, and they will adopt the best practices. What I felt was that, the advanced ruling mechanism was working perfectly under the central excise and service tax. They have not adopted that mechanism, but tried to, innovate somewhere there, and probably that has not went on pretty well here. So what I feel here is that, both as far as advanced ruling is concerned and as far as tribunal is concerned, there is a need for the government, both from central government and state government, to just take a step back. They should just appoint, only the judicial members, advocates, chartered accountants who are well versed in the GST law, and whatever the decision that body takes, be it the advanced ruling authority or the tribunal, GST tribunal, I think that should become final. So I think that was my 2 cents on the functioning of the advanced ruling authority and tribunals. And coming to the litigation which we are foreseeing in the near future, I think what I feel is that there are a lot of tricky issues. So there are some issues which are industry basis, industry-wide issues. Like for example, there are issues like as far as the IT industry is concerned, as to what what is the intermediary services. So under the export of services, the definition of intermediary is interpreted so widely by the government that practically half of the IT services can be said to be something which is facilitating the service of another party and can be deemed to be an intermediary. So all those kinds of disputes will be there, industry-wide disputes, be it IT services or e-commerce services. So all those disputes are there. I think a major chunk of the disputes would also come from, the government has been very, very, strict on the compliance or procedural part. So I feel that in the initial 1 or 2 years, because this is the period wherein we will deal with the initial first 2 years of GST, 17, 18 and 18, 19. People were not very sure about the compliances that they have made, the procedural requirements, whether that have been made, met or not. So I think a lot of disputes as to the TRAN 1, transition credit, a lot of disputes in relation to the matching of GST R2B and 3, etc. So all those issues will become, I think, which will come out once the audits get completed. And of course, we will have other disputes such as composite supply, mixed supply, input tax credit. All those disputes will remain. So all those legacy disputes which we used to have, I think that will remain. But under GST, a lot of procedural disputes are going to crop up.
Sorry, if I can just add to this chain of thought that we are now having. So when any new law comes, and while the expectation was that the department would be well trained in excise and customs and service tax and VAT, and the principles that were laid down there would be followed here, what has happened is at a administrative level, we've all seen when the registration is with the state versus registration with the center, the kind of treatment that the assessee gets, right? The same assessee in different states for the very same issue, the reaction, we are very, very frequently seeing, and practitioners of service tax and excise, for example, would never have seen things which VAT practitioners would have seen, which is give a reply in 3 days. Show cause is issued, and within 15 days there's an actual expectation that the reply is to be filed. I mean, we are seeing high courts intervening because an adjournment notice was rejected and orders are passed. This should not happen. There is absolutely no excuse for this kind of conduct, absolutely none. It is time that high courts come down very, very strongly on this kind of conduct. It is high-handedness, it is harassment. There is absolutely no doubt. These are very basic principles of natural justice, very basic administrative law principles that are not being followed. So one class of litigation is going to be, when we talk about administrative law litigation, and the initial phase of any law, any new law, take, for example, competition law, take, for example, GST that we are seeing now, or PMLA, IBC. The first few years are going to be laying down procedure, are going to be jurisdiction, are going to be administrative law. Because that's really where all the doubt is in the beginning of any evolution of any law. So I feel when it comes to merit-based, as Sudipta very beautifully put, admin and, merit-based litigation, I think now the stage is set. I wouldn't say immediately. I would say that maybe in the next 3 years, or 2.5 or 3 years later, you're going to see at higher forums more merit-based litigation. And when we talk about merit-based, we're talking about things like core issues, classification, valuation. Valuation is something that is still very, very unexplored. And this is it's more akin to customs valuation. It's very different. Things like how are you going to value stock transfers, how are you going to do cross charges, these are all things that are extremely complicated. I don't think anybody is very sure of the position that they're taking. There is always going to be a risk associated with the position that you take. Again, when it comes to a business planning, so things like classification, as much as possible, these have to be harmonized across states, right? Valuation, there is obviously you can't have different approaches in different states when it comes to valuation for ITC, place of supply. These are things that have to be uniform. Procedural things, you might have issues that different states might take different views, which may not impact your day-to-day business, running of your businesses. That's one thing. When it comes to, therefore, the kind of litigation that we foresee, it is going to be this. The risk, and this is the cost, risk versus benefit analysis that mostly clients will end up doing. It's a very, very first, it's my gut feeling that I'm telling is, if there is a red flag, if there is a show cause which is issued, and we're going to see, I think, hundreds, if not thousands of show causes that are going to be issued over the next 18 months to 2 years, is to hedge your risk. And when I say hedge your risk, it is take an opinion at that point. No, don't rely on advanced rulings because you don't know which advanced ruling to rely on, right? You don't know what is right, what is wrong anymore. It's, there's always some fact checking. It's like alt news. You don't know which is right, which is wrong today. So at a point when a show cause is issued or during investigation, take a position, okay, whether you are willing to fight this right till the Supreme Court, because one has to be prepared. If it's a demand which is more than 50 crores, and many cases where there are companies having multiple registrations, you are going to see demands go up in big numbers. Today, normal period itself, because thanks to COVID, has been extended to 7 years. And can you imagine the kind of impact on the bottom line that it's going to have on companies when, for normal period, you're going to have an impact of 7 years where you cannot collect that amount from your client, because if you do and you win by, you know, by your bad luck, if you win that and you've collected, you're not going to get refund of that because of unjust enrichment. And there is no way, I mean, there is no way you can collect that. You can't go back to some client that you have, a customer that you've sold to in 2017 July and say, you know, now you please give me the balance 6% because this product is no longer classifiable at 12%, which is what we all thought. So that is, I think, at a policy level, that is something that the government must recognize, that that is going against this ease of doing business. So those are very, very important parts. Even if it is distinct persons, you know, there is always an adjustment that is possible. ITC, there is always an adjustment that is possible. You take a risk. Do I pay today and avail credit and then move on with my business, right? Or do I say, from today onwards, I hedge my risk, I take a different view here and after without prejudice to my the practice that I did earlier, without prejudice to my my view of how I classified a particular product or how I avail credit up to that point. But that, so you hedge your risk in the sense that for 7 years or 8 years of demand, you probably will keep litigating till the Supreme Court, because it's going to be a sizable chunk of demand that you can't recover from your customers. But post that, I think the correction that industry will see is that wherever show causes are issued, unless it's an industry issue and the industry comes together to take a unified stand, they will start course correcting, because if you can pass it to your customer, it's the easiest way to do business.
Thank you. Another point linked to whatever she said, you know, exactly discriminatory decisions coming and litigation going right up to the Supreme Court. Department has a ferocious appetite for litigating further. So what will happen? You know, the adjudication orders coming from various states are going to be at variance. Already there's a talk of bringing tribunalization. There's a group of ministers formed, and on 1st of August, supposed to be the deliberation, the report will be given. Are we happy with the situation as it exists without tribunalization? Imagine 30% to be deposited before going to tribunal. And then the issues like she pointed out, place of supply and classification and even valuation, which are of paramount importance. Unless National Tribunal has been given jurisdiction on this, they will travel to various forums and then probably end up at variance with each other. You will end up having different classifications in a different state also. Are we buying for it? The states are asking for as many as 25, 26 tribunals in one state, having the jurisdiction of the state as is given today. And then there's going to be a national tribunal, which is going to be having national, regional benches also. So lack of uniformity is going to be there, which is going to derive every litigation either to High Court, not even High Court. I'll say that eventually the things will have to be settled at the Supreme Court level only. So why we are not contemplating something that there should be a special provision for taking up matters like classification and this thing at the earliest through SLP or whatever route by the Supreme Court. Of course, Supreme Court will exercise their discretion on SLPs. But are we by creating tribunals, I would say rather, creating a cumbersome process where there will be litigation which will be frivolous and ultimately everything will get decided at the Supreme Court? I'd like to elicit response. Maybe you'd like to give response.
Yeah, I just want to make one comment on that, because it sounds very nice actually. We all can go to Supreme Court for the things, but that will not be practically feasible. Then, you know, maybe we all will be lining up with our things. And secondly, since it is a very technical law, only tribunals, judicial person, I mean, of course, the other person also technical person can look at the things the way they should be looked, because we may not be able to present the things or make the judiciary understand that what we want to present. So I believe that is required. But the other end, which you said, the amount or the quantum of the demand which has been made at the departmental level, I think something needs to be done here. And I will connect this point with the point which Madam made for the principle of natural justice never followed by the department. Weird demands, like the kind of best judgment assessment do they make, And even if your turnover is X, your demand may be, X multiplied by another YZ. So we really need to approach the government or raise an issue that when the departmental level officer does something which is totally weird or which is beyond any kind of law, which is not legal. Because if we look at the people, as madam said that jo time hi nahi dete hain, within 3 days you have to reply within, that is one, and in fact very interestingly that is written in some rules also. वो तो एक अलग बात है, but I think all of us do have examples where we go to the officer. Like I take an example very little, that DGGI closed a matter after getting a deposit under section 74. The officer, assistant commissioner sitting in the commissionerate is ready to issue show cause notice saying, "Mujhe kya pata? I don't know DGGI. I don't believe on his closure." What will you do? So the point is, acha, okay, if you say, "Theek hai, I know I can fight, I know I can go to the various levels of the courts, but I am suffering right now." And what he did, if I say, "Okay, I don't agree with you," he goes and he just make an entry, he blocks my credit. He has no right to block my credit. So what will you do? Okay, fine, I can go to court, I can fight to any level. But the point is, today I am standing here, my business is suffering. My 60 lakh of credit has been blocked for no fault of mine, all fault of officer. So sir, I think this is very, very serious. So this situation, we as a group, when we are saying, at least jiske saath jo ho raha hai, I would say, I again, see what we can do in this country. Like people say, you are saying so much, but wo to wahi log karenge na. Only government can do it. But I think we need to come out of this mentality. We need, whatever wrong is happening, why don't we go and why don't we name the officer? Why don't we, I mean, I may be sounding very radical in this, but see, the point is, unless you have that courage to put an onus on the person who is doing wrong with you, we will keep getting wrongs with us. We are not saying do anything wrong with the person who has done his job fairly. But if somebody is taking me to the task, putting my business on the stake, I think we all have seen businesses suffering like anything. It's a pain. So why don't, and then another thing is, please write to the highest officer. Please write to the CBIC, to the commissioner, if anything happens with all the detail this has happened. So if 100 people will not write, maybe 2 will write. But the number is so. So sir, as a group, as an association, as an individual, if we want a solution to our problem, that is not in the Supreme Court, neither it is in the High Court. Our solution, because the kind of number of businesses we have, our solution lies at the departmental level reforms. And there, usme kuch bhi, I mean, one simple suggestion, sir, there should be a mechanism where we can actually tell that somebody, kisi ko onus to deke, we can place the responsibility or accountability. Accountability nahi hota officer ka, we all know that. But at least there should be a way where if something has been blatantly wrongly done, at least we should have a passage or channel to report it and get it corrected. So I think that's my...
See, the point she has made out is, ideally would like to have justice system closed doors only. But yes, then there is a risk and peril that there will be no uniformity of law and will be achieved only after long litigation right with the Supreme Court and all that. Alternatively, what she is suggesting is, and I think it's a very good point to make, that representative executives are the earliest. The executive should be responsible, maybe CBIC or somebody, some group in the council group of council of ministers, which can look into on a regular basis that, okay, these are the representations coming, and what has to be the response on a uniform basis throughout India. That could be one. Ideally, second way is that we look in for channels like, it has not been very prominently seen in taxation system, arbitration, conciliation and mediation kind of a thing. We just had a few experiments of that in the Settlement Commission. Unfortunately, it could take off in a small way, but then again, the same problem, bureaucrats being there and revenue bias at times existing. So it wasn't enthusiastically received. Is that kind of experiment possible in taxation? Where we put in some good jurist as one of the party, maybe tax official as one other party, or maybe somebody from trade, why not? After you are the one who has to run the business, why you shouldn't be made party to various dispute resolution system? If in civil laws and others, anybody can be who is mutually decided, why not have a panel even of the trade bodies and their representatives or even eminent jurists sitting on the panel, and tax alternative dispute resolution being brought in. So I'll just like to solicit views of Mr. Bhattacharjee on this.
Thanks. So I think couple of things first, and I'm treading on a little thin ice here. I don't think going to Supreme Court is necessarily the best thing for solutions. I would.
But dispute resolution is carried by the department up to Supreme Court. That's the problem.
I don't know. I was responding to the fact that, can we go directly on SLP? And often clients also suggest that, can we not short circuit? Yeah, Article 32. And, you'll read a lot of places that you can directly go. And I always say that, as tempting as it is, do not make that mistake. And I'll say no further because I might risk contempt. Another thing Rohini you touched upon, I think which has been very close to my heart in the last few months, which is accountability. And I cannot emphasize enough the need for accountability. And I'll tell you the trigger for this, why I started thinking in this line. There's a particular client that I have. It's one of the largest, conglomerates in India. They have a company in Jharkhand, one of the subsidiary company in Jharkhand. And there is a DGGI raid that happens. The CFO calls me at 11:30 in the night saying that, the DGGI, there are 2 cops posted outside my cabin. I have been told to speak to you, and only if I come out and say, give it in writing that I'll deposit this much, I'll be allowed to go. Familiar script. This is the new thing. They said that, and also, this is a listed company, by the way. They say that, and if you don't, not only will we arrest you, etc., tomorrow we will release a press note in the paper saying that 700 crores of evasion found in so-and-so, your stock price will come down by this much. Is it worth the fight? You deposit 20, 30 crores and get away with it. Why, let your net worth come down? I was enraged to hear that. I was like, this is classic stock market manipulation. That guy should be behind the bars for, making a threat like that. But of course, nothing of that sort happened, and that got me thinking. I had the chance to speak to the CBIC member GST thereafter, and a very approachable, very nice, very kind gentleman who is, whenever things reach to him, I have seen he takes action to the extent possible. I was talking about something else, and this thing came up, and this conversation is happening around the same time when all of you would recall a few CAs were arrested in, I think Haryana only, Gurgaon, and there was a lot of furor about that, and this entire conversation was happening. And I was telling him that, sir, under GST, and like in many other laws, there is a provision that you will find which protects public servants from prosecution, from any action. That problem or that protection exists only when the public servant is acting in good faith. When someone is coming to you saying this sort of a thing, or saying, I will arrest you, and on that threat forces you to deposit money during a search and seizure, that is definitely not acting in good faith. That is bad faith. There are provisions under Indian Penal Code to deal with people acting in bad faith, acting with malice, if a public servant is doing that. I think when it comes to accountability, probably, of course, I completely agree with the public support and the public voice part of it. But maybe a few test cases needs to be made. Maybe a few of these need to go behind the bars. I told the CBIC, the honorable member, that you are talking about a SOP, and of course a SOP is a much needed requirement. But in the SOP, for heaven's sake, include something for accountability. Unless you are punishing the bad apples, and you need only 5, 6 big examples, which needs to be publicized. I am not saying put 100 officers behind the bars, nothing of that sort. Put like really horrendous, extreme cases, publicize it, put them behind bars.
May I add something here only? Because in Bombay High Court, I think 2-3 months back, maybe continually, because they are actually doing very good in that line. Even in income tax, because the lot of problems are similarly here with faceless assessment. Many cases, the High Court has imposed costs on the officers, and in 1 or 2 cases, arrest has also been ordered. So I think now when we are talking about the groups, we need to publicize such things. As you said, only few examples are required, but the point is, things get unnoticed. Please continue.
No, I think very valid point, and high courts have been doing it, but I think what we probably need is a more institutionalized approach towards it. And I'll just come to the alternate dispute resolution point, which I think is a crying need, because clearly we don't have the judicial infrastructure. The cases which ultimately reach High Court or reach Supreme Court, which gets a fair hearing in time, etc., more often than not we get justice. But how many are those? How many people can afford to, etc., etc. So I think it's a no-brainer. We must have an alternate dispute mechanism. Advanced ruling probably was supposed to be that, but it has failed miserably, and I have no hope unless, because the problem is at the roots. I mean, if you have the revenue authority sitting in judgment, you are not going to get any better quality of outcome. So unless we sort of revamp the entire thing, and we don't need 28 advanced ruling authorities and 28 appellate authorities. I think 4 would suffice. 4 with good judicial members, like Shankey mentioned that pre-GST it was functioning very well. Yes, absolutely. I mean, of course, we lawyers even at that time used to occasionally crib if it went against us, but that was like a temple of justice compared to what we have today. So from that perspective, if we need to revamp or restore that model, and other, settlement commission. I think settlement commission also had a bit of a revenue bias. We have models in other countries to look at where people can enter into a settlement agreement for a period without accepting liability, without saying that, okay, this is where I went wrong, this is where I went right. Because tax ultimately is a financial, is a commercial sort of aspect. And to that extent, unless there is a very, very blatant sort of evasion, I think especially in interpretative issues, I think that benefit should be extended. Government should say that, I am saying 100 crores, you are saying 20 crores, let's settle at 30. And no fault. No one is at fault. We are not passing any observation on the merits. Let's close it. That definitely should be there.
So I just have 2 points to make, and then I can give it to Shankey. First is on the administrative control, right? While I agree with both points, one is of course systematizing or institutionalizing actions against erring officers or errant officers. That is definitely something that someone needs to really take the plunge and do it in a few test cases. Apart from that, I personally also feel that once a GST tribunal is formed, the very fact that these officers have someone to report to, because today they're saying, this person may or may not go to the High Court. Who do they have? Administratively, to somebody to rap on their knuckles. It's just if some petitioner decides to go to the High Court, because how many of our clients have refunds that are pending now, right? Refunds that are rejected and they don't know what to do. They don't know whether to go to the High Court. They're saying once the GST tribunal comes, we will go to the High Court. But we've gone and got some good orders, getting refunds, etc. But having a GST tribunal will not just on merits and not just on law, but administratively also instill some discipline. That's my personal view in the department. The second thing on this interesting alternate dispute resolution, I may have an alternate thought about that, which is I do also practice tax-related arbitrations, right? And there is in fact a crying need there among arbitrations to not arbitrate tax-related matters, because what is happening there is you don't have tax lawyers arguing or deciding or doing arbitrations where the core issue may be, passing on of credit, core issue may be, rate of change, classification, and things like that. So it is a line one must tread cautiously. I'm not sure if that's the right way of even for us to have an alternate dispute resolution, because there are 2-3 issues with arbitration even today systemically. One is the fact that these awards are not public, so you don't have any precedential value, right? So that is one problem. It's very, very transaction specific. That's again something that there is now a cry in the arbitration world that we should have arbitral awards that are public, so that there is so much wealth of judgments and orders that we should now start taking benefit of, rather than reinventing the wheel every time. So that's one thing. And arbitration has not led to the end of litigation, unfortunately. Even there we have section 34s and people keep going till the Supreme Court, especially if it's a PSU. They will not stop litigating till they reach the Supreme Court, and then the Supreme Court says no, SLP dismissed.
Charanya, sorry for a small interruption. What I feel, like I pointed out in the middle of discussion, that there are issues like whether a particular thing is a procedural lapse or substantive lapse. Maybe, we make out a provision that, okay, Chief Commissioner can condone it up to 10 by levying small thing. But as I also pointed out, who will decide? Yes. So do you think any role can be assigned to arbitration to that limited extent only?
Yes, so then in that case, it would be more at a departmental and an executive body. As you said, can have an oversight,
one member from the trade
ombudsman
also.
kind of, or a one member
only to that
to that extent. But yes, I think for when it comes to procedural issues, issues in terms of uniformity of issuing notices, uniformity of what kind of information is being called for, all sorts of absurd informations are being called for from clients. Risky business, I'm sorry, but who are you to judge whether I'm a risky business or not if I'm paying you legitimate tax? You cannot say that I cannot utilize my entire ITC. If, 2 of my output supplies are exempt, you can't penalize me for that. Why? I'm not answerable to anyone. We are not in a police state in that sense. So these kind of things definitely, to have uniformity within the organization, to have uniformity within the department, it does make a lot of sense to do that.
Mr. Shankey Agarwal is there. See, I just like to understand, what do you think can be a role of executive and why the trade body representation should be there at the some body which is formed under the aegis of Council of Ministers, like what we have in the Provident Fund, where 6 people come from employer side, 6 people from eminent politicians and others, and 6 people from this thing. So it does a lot of clarification and all that, which is binding on everybody, and they find it. Can we conceive something like, this? Maybe the trade should also become conscious of their right. They have been taking a lot of things in right. Give powers that, okay, there will be executive rulings which will bring uniformity. In that body, bring out people from trades, some number, revenue officials, same number, and maybe politicians and others, same number, finance ministers of this thing. Is it feasible and it should be done or not? That's what I would like to ask.
I feel that it is a very good idea and it is definitely feasible, and we also have a live example of something like this being implemented in SEZ. So in the SEZ we have something called Unit Approval Committee, and this has representatives of both SEZ authorities as well as the SEZ units representative, and they sit once in a month and they decide on a lot of these issues, niggling issues which are bothering the SEZ units or the industry. So probably what I feel is that this body could be a good idea, provided that it can provide clarity not on the legal aspects but on the procedural aspects, on some trade difficulties which the industry is facing. So probably it could be a good idea. I don't feel that there is any harm in creating that body. This could be a good idea which can work.
Charanya, you have a point of view on this?
No, so again, I agree that we can have a body like this. It can have a mix of trade as well as government representatives. The issue today is that there is a breakdown of trust. When we are in, when we moved in excise in long back from, to a self-assessment or self-removal and then self-assessment scheme, the whole idea was placing the trust within the, towards or in the SSE. I think that breakdown of trust is what leads to litigation, what leads to so much scrutiny, so much unnecessary baggage that is associated every time an investigation starts. So I think that sensitization is also required. But for that, of course, the industries, the SSEs must also act with responsibility.
Exactly. Very right.
Because one cannot always say that it is the department which is at fault. Today, I know we've really hashed and trashed procedures and things like that. But it is important I would like to my parting thoughts will always be that unless we act, 100% responsibly. You know, even one or two errant people will evoke a symptomatic reaction, which is what we are seeing today.
So I think we are closing on the concluding portion. So I'll just sum up some beautiful suggestions coming, and I hope you all enjoyed the interaction as much as we did, interacting very well-informed panelists. And there are a lot of suggestions coming. Yes, there's a need to reduce litigation by bringing in uniformity, but how do we do it? Adjudication is going to various states, so there will be some lack of uniformity. If we form too many tribunals, there will be a lack of uniformity. Issues like place of supply, classification, and valuation, they need greater clarity, and at the earliest. So the finality has to be reached. Maybe, one way is that keep on litigating department also does on these issues. It goes right up to the Supreme Court, increasing cost for anybody who has entered on the litigation. That's one part of it. Second is that executive instructions can play a very important part, but there our panelist suggestion, as we all agreed, was that you form a body where people from trade are also going to be there, revenue officials are also going to be there, and something like what you have the board of under the Provident Fund Act and other, and where the representative of the politicians and finance ministers can also be there. Let that body be vested with the power to issue instruction to bring uniformity on any aspect. We used to have the concept of tariff conference earlier, and the Central Excise and Custom Law loosely still exists. So that was the apex body bringing out clarification, and it was binding on the officers. So something similar can be done. Maybe the political class to meet its aspiration, as they keep on saying about it, now being the federal tax. 6 members can go by rotation and keep a new members can keep coming. Trade bodies can select out of listed people, and then revenue officials. And at that time, bring out the rulings from there. That should be the instruction forming body, rather than somebody just writing with a revenue bias or coming out with this. So with these, just left with 1 minute, I thank all my panelists, Mrs. Rohini Aggarwal, Mrs. Bhattacharjee, Charanya, and Shankey. Thanks a lot.
Thank you so much. I would now like to invite our esteemed Taxo subscribers to present the mementos. Ma'am, could you please, we'll just present. I would like to invite Advocate Arvind Vijay from Rajasthan to present the memento to CA Rohini Agarwal. I would like to invite CS Sachin Bahal, DFCCIL, to present the memento to Ms. Charanya. I would like to invite CMA Amit Tandon Wrights to present the memento to Mr. Shankey. Mr. Somesh and Mr. Sudipta have already been presented with the mementos during the previous panel discussions. Can we also have a group photograph?
You are too many, huh?